Welcome to literary and jury charge practice. Let's go ahead and get started with some warm-up. Ready? We move to relieve the court reporter of her duties under the Code of Civil Procedure 2025 that the original of today's deposition transcript be mailed directly to the deponent at her stated home address, that she have 30 days to read, review, and sign the deposition under the penalty of perjury. Any changes or corrections to the deposition transcript to be made on a separate errata sheet provided by the court reporter, also signed under the penalty of perjury. The court reporter to provide her with a mailing envelope with postage to my office in Riverside, and upon receipt within 10 days will forward to defense counsel a copy of the signature page, cover sheet page, and errata sheet page of the deposition transcript. Applicant's attorney is a paperless office. We forego the certified paper copy you normally provide. We prefer an electronic copy in PDF format. You can email that to me. If the original transcript is lost, stolen, misplaced, destroyed, or otherwise unavailable at the time of trial or any subsequent legal proceeding for which it may be required, an unsigned certified copy may be used with the same force and effect as the signed original. Now for some literary material. And this is an article in the Journal of Court Reporting from NCRA. And it's called My Steno Cinderella Story. Ready? When I was a student just starting to learn my theory, I was given a writer that I'm sure most of you have written on at some point or another. It was dark green with an old pull-out metal tray. The tripod was made out of steel, and the whole thing weighed a ton. Part of me thought this was just some hazing prank that I had to go through to get the nicer writers. But no, this was what I and the rest of my classmates were stuck with. While I was progressing through my theory classes, I fell in love with court reporting and developed a love-hate relationship with my writer, which I nicknamed the avocado. For the sake of this story, I wish I would have nicknamed it the pumpkin. While everyone was upgrading to the newest and best models, I was still inking my ribbon and reading from paper and dreaming of the day when I could write on those magical paperless models. I would tell my boyfriend how much I dreamed for the newest and greatest electric paperless student writer, or how sick I was of typing up my paper notes on a computer. I was so beyond the archaic methods of the past and yearned for the efficiency of the future. All right, it's not over. Well, we'll get back to that. Let's do some jury charge practice now. And the subject of this jury charge is attorney and client. Ready? Ladies and gentlemen of the jury, an attorney at law, when retained by another, is entitled to fair and reasonable compensation for the professional services rendered. There is no fixed standard by which the value of the services of an attorney can be determined. His value and reasonable price necessarily vary with the magnitude and importance of the particular case, the degree of responsibility attaching to the work performed, the difficulty of the matters involved, the time consumed, and the benefits derived. In ascertaining the value of such services, you will exercise your sound discretion and judgment and allow such reasonable amount as you believe constitutes a just and fair compensation for the services rendered, not to exceed the sum of $3,000. In determining the value of the services rendered, you may take into consideration the fact that at the time of undertaking the work, the attorneys bound themselves to make no charge for their services if they failed to secure beneficial results. The fact that these services were to be rendered on a contingent fee basis, which means that no charge was to be made unless beneficial results were obtained for the defendant, should be considered by you in determining the value of the services. Okay, what words do we have in here that we might want to give a little extra practice? We had magnitude, constitutes, compensation, contingent, all right, we'll finish that one up in a bit, but now let's get back to our Cinderella story. Ready? A few years went by, and I found myself plodding away in my first speed building class. I came home from a productive day at school to find an envelope on my bed. I didn't order anything, so as you can imagine, I was surprised to see my name written on the package. Dan, my boyfriend, told me to open it. Inside, I found the student version of the cat software I wanted inside. I squealed with excitement, but in my head I was thinking, he is a computer programmer. Didn't he know that I use a manual writer? Still, he was being so sweet. I was so thankful and overjoyed. I promised him that I would start learning all the bells and whistles right away, so when I was able to afford an electronic writer, I could start using it with ease. He looked at me with confusion, as though he didn't even think about my writer, then acted confused and upset that he made such a rookie mistake. All right, let's do some jury charge practice. Ready? It is customary for attorneys to charge more when they undertake to render professional services on a contingent fee basis, because under such a contract, no charge can be made unless beneficial results are obtained, no matter how much actual work may have been performed. You are instructed that the mere fact, if it be a fact, that the litigation did not result to such advantage to defendant as he may have hoped it would, does not preclude the right of plaintiffs to recover in this action if the defendant employed the plaintiffs to prosecute the suit in question. The plaintiffs are entitled to be paid for their services. Okay, some words to practice. We have customary, undertake, contingent, beneficial, litigation, prosecute, do a little bit more, read a little bit more from our Cinderella story. Ready? I've got to tell you that when I'm well into my golden years, I think I will be able to remember those next few minutes with perfect clarity. He then went into the closet and pulled out a much larger box. My eyes widened. My heart was racing, and I had to sit on the bed due to shock. He let go of the package, and it plopped in front of me on the bed. He then handed me a pair of scissors. Open it, he told me. All right, we'll have to wait to hear what's in the box. That will conclude our literary and jury charge practice.